Welcome to The Explainer. Today we're diving into a landmark Supreme Court case that really forces us to ask a tough question. When police are racing against the clock to solve a brutal crime, how much of our own privacy are we willing to sacrifice?
This is the question right at the heart of our story today. And it's not just some abstract legal debate. It's a question police and judges have to grapple with every single day, especially when a serious crime has been committed and crucial evidence is literally disappearing by the minute.
So, Section 1. A search, a right. The Charter versus common law. To really get to the bottom of this case, you've got to understand the two powerful legal forces that are clashing here. On one side, you have an ancient police power, and on the other, a modern constitutional right. And this is the core principle at stake. Section 8 of the Charter. It's our constitutional shield against the state going too far. It protects our privacy, our dignity, but everything, and I mean everything, hinges on that one word, unreasonable. What does that really mean when police are in the middle of a high-stakes investigation?
Which brings us to Section 2, the case of Ali Saeed, a crime and a very controversial search. So what's the actual story that pushed this question all the way to the Supreme Court? Well, it all started in the early morning hours in Edmonton way back in 2011.
Just look at how quickly all of this unfolds. A horrific crime takes place at 4 a.m. Just 2 hours later, police have a suspect in custody, identified by a witness. They are convinced the victim's DNA is on his body, and they believe that evidence could be lost at any moment. So they make a hugely controversial decision. They perform a penile swab to get that DNA, and they do it without a warrant. And now Section 3, a charter right on trial, where the lower courts disagree. That DNA evidence was damning. It led to a conviction. But the big question was, did the police break the law to get it? And this is where the legal system really started to disagree with itself, setting up a problem that only the Supreme Court could untangle. This is where the legal tension becomes crystal clear. Both the trial judge and the Court of Appeal agreed the police violated Mr. Saeed's charter rights. The search was unreasonable. But, and this is the crucial part, they also decided that the DNA evidence was just too important and too reliable to be ignored. So they allowed it in court and the conviction stood. You can see the contradiction, right? That's what paved the way for a final confrontation at the Supreme Court. So here we are in Section 4, the Supreme Court's answer. The case lands at the Supreme Court, and the 9 judges are faced with this fundamental question: did this invasive, warrantless search cross the constitutional line? Their answer wasn't just going to affect this one case. It was going to redefine the rules for policing across the entire country. And in a stunning 7-2 decision, the majority of the court came back with a really surprising verdict. They found that the police did not violate Section 8. The search, they said, was lawful, and the conviction stood. So how did they justify this? Well, they didn't just give the police a green light. Instead, they took the old common law power to search someone when they're arrested, and they kind of updated it for the charter era. They created a brand new 2-step test. First, police have to have solid, reasonable grounds to believe they'll actually find evidence. And second, the search itself has to be done in a reasonable way that respects the person's dignity. And the court got very specific about what reasonable means here. They laid out a clear checklist to protect a person's dignity. The search has to be at a police station, okayed by a supervisor, the person is told why it's happening, and they even get the option to do the swab themselves. And because the police in Saeed's case had followed most of these guidelines, the majority concluded that their actions, while definitely invasive, were in fact constitutional. But let's move to Section 5, because not everyone on the court agreed, not by a long shot. 2 of the 9 judges wrote these scathing dissents, arguing that the majority had gone way too far, basically giving police a new invasive power without any judicial oversight. Justice Karakatsanis' argument was that a genital swab is just so profoundly invasive that it falls completely outside the traditional powers of the police. She felt the search was illegal, but here's the twist. She still allowed the evidence to be used in this one case, mainly because the law was so murky at the time. Her point was really to draw a line in the sand for the future. This kind of search, she said, requires a warrant, period. And Justice Abella's dissent? It was even more forceful. She argued the police showed a blatant disregard for the charter. In her view, the violation of dignity was so extreme that allowing the evidence in, no matter how reliable it was, would do more harm than good to the justice system in the long run. This table really clarifies the fundamental disagreement here. You can see the three competing legal philosophies at work. You've got the majority, who created new rules to permit the search. You have Justice Karakatsanis, who found the search illegal but made a one-time exception for the evidence. And then Justice Abella, who argued that both the search and the evidence should be thrown out completely.
So Section 6, the new rules of search. Beyond all the legal arguments, what's the real-world impact of this decision? Why does this case matter to you? It's simple, really. This case redrew the line between police power and individual privacy in Canada. The practical outcome, the key takeaway, is that the Supreme Court has now given its official approval for this kind of invasive, warrantless search, but only if police follow those strict new rules. This decision created a whole new playbook that police forces all across the country now use. So, has the court struck the right balance between our security and our privacy? The R v. Saeed decision tried to find a workable solution to a really messy problem, but it leaves us with this lingering question that is still debated today by lawyers, police, and privacy advocates. In our collective search for justice, have we struck the right balance? That's the question this case leaves for all of us to answer.